which is expected to rule on a new law banning high-capacity magazines.
The Supreme Court has rejected challenges to assault weapon bans in Connecticut and New York.
State bans on assault weapons, and the Supreme Court is at this point staying out of the fight.
In 2024, a Cowlitz County judge overturned the law, but the Washington State Supreme Court upheld it.
Includes the sale, import, manufacturing, and distribution of these magazines that hold more than 10 rounds.
A major win for gun safety advocates. The Supreme Court will not hear a challenge to Maryland's assault weapons ban.
All right, everyone, I need to level with you. The Supreme Court just convened on Duncan v. Bonta, Gators v. Ferguson, Viramontes v. Toth, and NA v. Lamont. These represent the four most consequential Second Amendment disputes currently pending before the nation's highest tribunal, and each and every one received yet another relisting. No grant, no denial, simply kicked further down the calendar. Once again, and I'll be frank with you, that's an ominous development. I'm going to dissect precisely what this signifies, what unfolds next, and particularly what residents of California ought to be bracing for. The ramifications there diverge dramatically from anything we've witnessed in other jurisdictions. Here's why this carries personal stakes for you. If you possess a magazine holding greater than 10 rounds, and for the majority of you with a factory Glock 17, stock AR-15, essentially any contemporary firearm in your collection, what California, Washington, Illinois, and Connecticut have elected to designate as a large capacity magazine. These four disputes collectively contest magazine prohibitions and, in certain instances, semi-automatic firearm bans spanning numerous states. Should the Supreme Court deny certiorari, meaning they refuse to adjudicate these matters, the appellate determinations remain binding, and the prohibitions persist, and specifically in California. We're not discussing a prohibition on prospective transactions. We're addressing a prohibition on possession itself. That translates to magazines already in your custody, lawfully acquired, resting in your vault for years. The justices must determine whether this prohibition on magazines exceeding 10 rounds infringes upon the right to keep and bear arms. A firearms retailer submitted a petition to the U.S. Supreme Court seeking to overturn Washington's high-capacity magazine prohibition. The state Supreme Court is poised to rule on novel legislation banning high-capacity magazines in Washington, alongside another gun safety initiative, a prohibition on high-capacity magazines. California demands you demolish them, relinquish them, or transport them beyond state lines, and the countdown commences the instant the tribunal issues a denial. So no, this isn't some theoretical legal abstraction. This concerns your assets, your liberties, and a countdown that could expire prior to June's conclusion. Allow me to guide you through what's genuinely transpiring procedurally, because the minutiae here are pivotal. The Supreme Court conducts private conferences wherein the justices determine which petitions to accept. Under the tribunal's internal protocols, 4 affirmative votes are required to grant certiorari. That's the rule of 4. If 4 justices wish to hear a matter, it advances to oral argument. Otherwise, it's denied and the lower tribunal's ruling achieves finality. With the petition lodged, this could ascend to the Supreme Court should the justices deem it nationally consequential. Considerable deliberation revolved around whether a magazine qualifies as an arm under constitutional analysis. High-capacity magazines are unnecessary for self-defense and are regularly utilized in mass shootings. Now, Duncan v. Bonta, that's the California magazine prohibition dispute that's been waging for approximately a decade. Initially filed before Judge Roger Benitez in the Southern District of California, it has now been conferenced roughly 14 separate occasions. 14. That's an exceptional volume of relistings, and here's why that's consequential. Last term, we observed a matter styled Snope. The United States follow an essentially identical trajectory. It endured repeated relisting, conference after conference, only to be denied at the term's terminus in June. Parallels between Snope and what we're presently witnessing with Duncan are inescapable. In customary self-defense scenarios where an individual discharges a firearm, merely 1 or 2 rounds are expended. In 2024, Cowlitz County jurist nullified the statute, though the Washington State Supreme Court upheld it. The measure covers the sale, importation, manufacturing, and distribution of magazines containing more than 10 rounds. Gators v. Ferguson contest Washington State's magazine prohibition. Viramontes v. Toth constitutes an assault weapons dispute originating from Cook County, Illinois. NAGR v. Lamont. That's the National Association for Gun Rights contesting Connecticut's prohibitions on both semi-automatic firearms and standard capacity magazines. All 4 were conferenced the preceding Friday, May 1st. All 4 4 were relisted without disposition. Hey, and I should note that moving forward, the remaining conferences are transitioning to Thursdays rather than Fridays. We'll still receive the orders list the subsequent Monday, however. The forthcoming conference convenes May 14th. Beyond that, only a limited number of conference dates remain before the tribunal's ultimate conference on June 25th, immediately preceding summer recess. The most meaningful method to honor victims isn't through symbolic bans on particular classifications of arms, but through preventing subsequent attacks. Now, this proposed ordinance prohibiting assault weapons, high-capacity magazines, and ghost guns. I believe Minnesotans have made their position unmistakable. They endorse a ban. So let's examine what denial actually materializes as in practical application, because it varies substantially depending on which dispute we're examining. In Gators, Viramontes, and NAGR, the prohibitions in those jurisdictions are already operative. No stay remains in effect. If certiorari is denied, the existing circumstances simply continue. The statutes remain enforced. It's detrimental, but the quotidian reality for firearm proprietors in those states doesn't transform overnight. Hey, the Supreme Court has rejected challenges to assault weapon bans in Connecticut and New York, and the state Supreme Court affirms the Protect Illinois Communities Act prohibiting assault weapons. Breaking news from the Supreme Court this morning concerning the weapons deployed in the San Bernardino massacre. A significant triumph for gun safety advocates. The Supreme Court will not entertain a challenge to Maryland's assault weapons ban, prohibits dozens of specific rifle and handgun varieties, 50 caliber firearms, attachments, rapid-firing mechanisms. Duncan presents an entirely distinct scenario. Under Federal Rule of Appellate Procedure 41, H, when the Supreme Court denies certiorari in a matter where the mandate has been stayed, meaning the lower tribunal's directive has been suspended while all parties awaited Supreme Court action, the stay evaporates. The Ninth Circuit Court of Appeals is then obligated to issue its mandate expeditiously upon receiving that denial order. Once that mandate issues, California Penal Code Section 32310 activates with complete force, and Section 32310 doesn't merely prohibit the sale or transfer of magazines exceeding 10 rounds, it prohibits possession, unequivocally. If you retain them, California instructs you to permanently alter them to accommodate 10 rounds or fewer, remove them from the state, surrender them to law enforcement for destruction, or deliver them to a licensed firearms dealer. There exists no grandfather provision. There exists no statutory grace period. Hey, though the Ninth Circuit could theoretically construct a brief compliance window under extraordinary circumstances, that determination rests exclusively with the Ninth Circuit. And given that tribunal's record on Second Amendment disputes, I wouldn't anticipate magnanimity. How? Permit me to furnish the wider panorama. The Supreme Court rendered its decision in New York State Rifle and Pistol Association, Bruin in June of 2022. That was the landmark opinion establishing the text, history, and tradition test for evaluating firearms regulations under the Second Amendment. The High Court determined that the prohibition doesn't transgress constitutional protections. Governor J.B. Pritzker enacted the prohibition earlier this month. Truly, approximately 5 major determinations remain pending, and they implicate extraordinarily contentious matters. There's been substantial discourse regarding restricting ownership of assault rifles, what are commonly termed assault weapons. They declined to hear a challenge to Connecticut's assault weapons ban and one operative in New York. Under Bruin, the government must demonstrate that a contemporary firearms statute aligns with the nation's historical tradition of firearms regulation. Magazine prohibitions possess an extraordinarily feeble historical foundation. There exists no founding-era parallel to informing citizens they cannot possess a factory-standard feeding apparatus for their firearm. Judge Benitez articulated that point explicitly in his district court opinion in Duncan. The historical record simply doesn't substantiate it, and yet here we are, observing the Supreme Court apparently running out the clock on precisely the disputes that would permit them to apply their own Bruin standard to these statutes. That's genuinely perplexing. It's exasperating, and I suspect many of you share that sentiment. The new statute ignited a firestorm of criticism from gun rights proponents. Indeed, it was promptly challenged. The Supreme Court refused to entertain a legal challenge to a municipal ordinance adopted in 2013, a stringent assault weapons ban. And Maryland rapidly followed suit. 9 states advanced prohibitions on assault weapons and magazines, statewide bans on assault weapons, and the Supreme Court is, at this juncture, remaining aloof from the conflict. We can be confident that whether we're present Thursday, probability is mounting that we'll receive one of those significant cases. I also wish to situate this within a broader framework. A circuit split is fermenting on these questions. Divergent federal appellate tribunals are reaching contrasting conclusions regarding whether magazine prohibitions and assault weapons bans withstand Bruin's historical test. That's It's traditionally precisely the species of conflict the Supreme Court intervenes to resolve. Hey, the fact that they appear disinclined to do so here reveals something regarding the tribunal's internal dynamics that frankly ought to alarm every firearm proprietor in America, irrespective of your state of residence. If the tribunal permits California's possession prohibition to stand without review, that transmits a signal to every other state legislature contemplating analogous statutes. New York, New Jersey, Hawaii, Massachusetts, they're all monitoring. Declining to accept this matter and leaving the lower tribunal's ruling undisturbed relegates the Second Amendment to secondary standing. Law enforcement personnel even executed a statement declaring they wouldn't enforce the statute. The dispute eventually reached the Illinois Supreme Court, where those state statutes. Of course, this signifies there will be no challenge, no constitutional inquiry regarding those state statutes. This could merit closer scrutiny in the forthcoming term or two. So it's not the definitive pronouncement, but at minimum for the president in Maryland. So permit me to offer my candid evaluation. Am I certain these matters will be denied? No. Nobody beyond those conference chamber walls knows definitively. And I genuinely hope I'm mistaken. But the pattern we're observing, 14 plus relistings for Duncan, the Snope precedent from last term, and merely 7 conferences remaining before summer recess, all of that indicates a trajectory I find disquieting. I'd estimate the probability of a grant at this juncture somewhere around 15 to 20%, perhaps lower. And that's agonizing to articulate, because when Duncan was initially petitioned to the tribunal, the case for granting it was overwhelming. The historical analysis under Bruin, the circuit split, the severity of the statute. It satisfied every criterion, but the Supreme Court operates according to its own chronology and its own internal political calculus. Currently, those political calculations do not appear to favor our position on this particular cluster of disputes. Who voted for the A50 amendment? You voted to maintain firearms more readily accessible to convicted violent felons. You voted to perpetuate the sale of weapons of war, assault weapons in Minnesota. The measure allocates $20 million for school safety and millions additional for mental health services. Restrictions on public carry and secure storage, which incorporate stricter requirements for reporting lost or stolen firearms. Here's your status update, and this is the portion you must retain. As of today, the stay in Duncan remains active. Your magazines remain lawful to possess in California presently, though that could transform with a solitary Monday morning orders list between now and June's conclusion. The next conference convenes May 14th, with the orders list appearing the subsequent Monday. If you're in California and you own standard capacity magazines, you must be monitoring every single one of these conference dates. And for those of you in Washington, Illinois, and Connecticut, a denial doesn't alter your present circumstances, but it does slam shut your most promising avenue for relief at the federal level for the foreseeable future. We'll be covering every single one of these conferences as the orders arrive. That's all for today, everyone. See you in the next video.